situation last year where an employee gave us a letter to say that their partner was seriously ill and needed to go to have tests and operations and various other bits and pieces. But we were concerned about the genuineness of that letter, and therefore I made contact with the hospital, not to ask them about more information regarding the content of the letter, but just to ask, is this a genuine letter from your organisation? It turned out not to be. But would that in any way have breached?
First thing to say is GDPR doesn't change the law in that regard. If you are, the hospital would have been in breach of their own data protection obligations if they gave you too much information. But no, if you're saying, look, I've received this letter, is it genuine? There'd be a query in my mind about whether the hospital ought to be responding. But did you breach your obligations there? No.
And I think this is back to the legitimate interest. You're trying to run a business. There's certain things you have to do, which includes monitoring employees, attendance, etc.
Detecting fraud is a legitimate interest.
And therefore you would have a legitimate interest in doing that and pursuing that if you had reasonable suspicions, reasonable belief, which clearly you did.
So from that point of view, that takes us on to the question of privacy notices, because effectively you're saying in an employment context, consent is pretty much a dead dog, so privacy notices become all important. Just before we look at that, who here is, I'll come to the question in a moment, who here is particularly concerned at looking at the internal picture in terms of employees, and who is very concerned at the external picture in terms of customers? So whose primary role would be the internal picture? Okay. And whose primary role would be the external picture? Okay, so it's got sort of 50-50 on that. Okay.
You need to ask as a hybrid as well.
Okay, who is a hybrid? Okay, that's helpful, thank you. So to address, with recognition that we need to look at that external picture, the internal picture and the hybrids, can we just have a brief word on privacy notices? Who wants to pick?
Yeah, I mean, I'll start and then I'll probably hand over to Darren, easiest way. But effectively, your privacy notices need to cover, the purposes as why you're collecting data, and all this is documented, your reason behind it, how long you retain the data, etc. From an internal perspective, because you can't rely on the consent, your privacy notice need to be quite clear. And there's a couple of things you can do from a practical point of view to make employees aware of that. You don't need to change their contracts or anything like that. What you can do is you can just publish the privacy notice and say this is how we use your data, just so you're aware. So you can cover that option off on your internal employees, or issue a letter as an addendum to the contract that it clarifies why you're collecting data and personal data, etc. From an external point of view, then you should have privacy notices which are clearly visible and explains why they're doing the data, but that will depend on who's coming in for what aspect. Recruitment, for example, if you're recruiting, then there should be a privacy notice visible to recruitment. So there's all these sort of assets, but the point we're making is you need to review your existing privacy notices to make sure it covers the GDPR and the basis.
So where it should be will depend upon the use that you're putting to it.
Yeah, because you're collecting data in different ways, let's be honest. Someone that's doing it for recruitment is doing it slightly different from an HR team for employment. Someone that's doing it for marketing is doing it for slightly different reasons. So your privacy notices need to be quite clear how you're collecting that data, the purpose of the data, and what legitimate legal right you have to collect that data, and how long you're retaining it for. And so there is a research on that. Anyway, off you go.
In the employment law context, two big points to bear in mind. Number one, the need for conciseness, transparency, accessible usage, etc. Actually, 3 points. Number two, GDPR says that included within, there's a list of stuff that has to be included within privacy notices, and that's in your pack. But to come back to your point, one of the things that has to be included is if your processing condition is legitimate interests for a given piece of processing, so let's say monitoring email usage, or you have to say what your legitimate interest is in relation to that piece of processing. Okay, so that's why it's important to be clear about what your processing condition is, because if it's legitimate interests for, say, email monitoring or internet monitoring or CCTV, you have to say in your privacy notices what that legitimate interest is.
Okay, so picking up the fact that we've got quite a lot of people concerned about the external picture and the hybrid picture, tell me what you want about privacy notices from the external perspective.
From the external perspective, the principles are exactly the same, but it's the application that's different. So you've the list on page, no need to look now, but the list on page 8 of your handout applies equally to the external picture as to the internal picture. But if you're looking at, for example, legitimate interests in the context of a service provider type situation, and you weren't relying on consent, then the legitimate interest specified in the privacy notice will be different. But remember that when you're talking about the external picture, consent is a long way from being a dead dog. Consent just got a whole lot more bolstered. So much more often in the external picture, legitimate interests won't come into the equation. In marketing and sales, you're going to be relying on consent most of the time.
Okay, so marketing and sales, you will. What about external processing in of payroll data, external processing of sort of medical reports, external advisory services? Just briefly on those, and then I'm going to just pick up the two questions that are arms that have gone up.
Well, let's talk about payroll and medical. First bullet point around payroll is the processing condition there on page 6 would be in compliance with a contractual obligation, because you've got a contract with the data subject. You have to process their pay information.
So you can externalise that.
You can externalise that, no problem.
What about the other one?
With medical information, that's special category personal data, presently known as sensitive personal data, and there's a processing condition in GDPR which basically says if you're doing it in an employment context, it's fine as long as you apply appropriate safeguards. The Data Protection Bill, which is still going through Parliament, which will become the Data Protection Act, contains this outline of the safeguards, and basically you need to have policy documentation in place which explains how you're going to achieve the data protection principles and explains what your retention periods are in relation to that sensitive personal data.
Okay, let's just pick up those 2 points. I'm sorry I've kept both of you. Is yours on this topic or is it moving?
No, it is, yeah.
Okay.
So it's deepening on the external marketing.
Okay.
Because
And can I just check, is yours on which side of it?
Internal.
Internal. Okay, well, we'll go external first then, shall we? Because you hand went up
I
first.
think that last point clarified that consent is going to be a lot more important
Yeah.
in marketing and sales, and it's not a dead dog, anything but.
Yeah.
So I want to go deeper on that, perhaps with Jason. What's actually going to change here in terms of our ability, and indeed, marketing campaigns and things like that, in your view, and what do we need to look out for?
Yeah, it's a great question.
I guess the biggest change now is that whereas before somebody would make contact with you and ask for something about a particular interest, and the natural assumption is that then you would put that person onto your mailing list and then continue to mail them. And the biggest change now is that you can't do that without specific permission to add them to your mailing list. So you can obviously provide them with the information, you can obviously follow up on that information and encourage them to move forwards, but you can't naturally assume that they've given you consent to add you to everything else. The personal data is much more difficult. So if you've got private email addresses, Gmail, Yahoo, whatever, it's much tighter now in how you email those people. You literally have to have a specific consent to email that person. The business side is different. As I say, you can still now have what we call relevant information sent to your person in a particular position in a particular company. That's fine. So you need to be very careful of, if you've got an email list and it's full of Gmail accounts, then there's not a lot you can do. You have to be very, very careful now in how you use that data.
But can you email them out to say, do you want to? You can't even do that.
No.
So you're screwed.
There was a case of a company who emailed all their lists saying, "Can we add you to a mailing list?" and they got fined because basically they didn't have permission to ask that.
So It's going to be a risk management issue, isn't it?
So,
thank you for asking. And it comes down to risk management, doesn't it? So if you email that, people are going to be choosing the risk profile they want to take to some extent.
Well, on the same extent, direct mail as well. So don't send direct mail unless you've got person's consent with their name on it.
How do you get consent?
Welcome to the world.
Without asking them for it, is what I mean.
So
you
basically,
can't send them an email to say, can I have your consent?
no. So now basically it comes down now to what they call things like advertising, online promotions, content marketing, where you're changing the emphasis, as it's been for a number of years, where you're now saying, right, I've got this lovely piece of information, I think you should come and get it, and then you're offering it. But at the same time, it's how you word both your email and your sign-up boxes. So
you're trying to pull away from the totally unsolicited.
Yes.
So towards someone, for example, offering a freebie, free document, free whatever, and then you going there and then consenting within certain parameters. And once you've got that, it gives you the opportunity to offer an extension of those parameters.
Yes.
Right.
Consent's going to mean something in the new world rather than being a euphemism for just send it anyway.
So before we get onto the internal, and I haven't forgotten it, more on this external side, there's a couple of... your hands popped up several times, sorry.
Follows on to this gentleman here. We often get supplied data from clients to mail things on their behalf. So when they send us that data, can we safely assume that they've already got the relevant?
It's a really good question. So do you want to contextualise that slightly? So you're supplied with data, and you are told, please mail this person on behalf of that one. Yeah.
Do some work for a company pension scheme.
Yeah.
They'll send us data for all of their pension members.
Yeah.
We'll receive a pension from them and ask us to mail them information.
Okay.
I have no way of...
No, and I think I know what the answer's going to be, and I think I've heard these guys shunting it this way.
The answer is you're a data processor. So big change in the new world is that you'll have direct obligations under GDPR. Another big change is that you'll have to have minimum contractual terms in place with your data controller. The short answer is that you would hope that your contractual terms will cover off this type of situation, but although in theory the ICO could come after you, when they're looking at this, they'll look at how negligent you've been, and actually if you've got the right contractual terms in place with your data controller, which should be along the lines of, you must make sure that if we're going to be marketing people on your behalf, you've got the right consents, the chances of you getting in too much stuck over that, I think, are quite slim.
And Sean, who walked in, who's the one who texted me, standing in the back there, head of the corporate commercial team. I guess those guys are constantly now looking to tweak those standard terms and conditions to extend them to cover those wider GDPR implications. More on the external side.
External, this is external. My husband provides the service of our business to the clients, and I send out invoices, receipts, and so on to the clients. Very often, sometimes it's with an invoice, it might even be separately. I say things like, apart from the receipt, thanks for your money, here's a receipt. But I also say, if you would like to know anything, if you have not yet investigated the possibility of R&D tax credits, let me know, because I have a lot of contacts who do this, if I put that separately from the receipt is obviously as part of the job, but if I write to them separately, I think, oh, so-and-so, I wonder, we didn't talk to them about R&D tax credits, they might be interested.
So it's extension cell, it's the classic extension cell. You've just bought some, from us, you might like to think of this.
It's not business for us. I'm saying, if you would like to know about R&D tax credits, I have lots of contacts.
Okay. Well, for some people, it would be an extension cell for. Yeah, sure.
There's no benefit for us whatsoever.
Okay, but for some it would be. It would be an extension cell, and for others it would be an onward referral that we're talking about here.
But with
okay.
No financial benefit.
Okay. Well, for some it would be. So let's just run through the two scenarios that produces. Who wants that? Jason, do you want to go first on that? You're sitting forward, so you're at risk.
All right, I'll sit back. to me, that would be absolutely fine.
Agreed.
You are not, if you were transferring your information directly to the tax credit people and said, here's a list of our contacts, off you go, obviously that you would be in breach then. But the fact is that you are following up. They're an existing customer.
Yes.
You have an interest in them.
Their well-being. I mean, you know, it would help them actually.
Yeah,
if they
and
hadn't
it's an
already done
upsell. It's an upsell
Yeah.
opportunity. If you're making money off the tax credit or not, that's your call, obviously. But yeah, you would have no problems at all.
So,
with that.
so you think the two scenarios we identified, you're all comfortable with?
Yeah.
I
okay.
think also you're inviting them as well. You're not forcing them in any way.
No,
shape.
Okay,
no,
exactly.
You're
That's
inviting
correct.
them to say, if you're interested in this, go to this.
Yeah, let me
So,
know.
so
or-
then at that point they should be getting consent. Yeah.